morning, and thank you for joining Thompson Hine's weekly coffee chat series. My name is Andy Davalla. I am a partner in Thompson Hine's investment management practice group. Joining me today is my colleague, Debbie Brenneman, partner in Thompson Hine's labor and employment practice group. She represents management in all areas of employment law with a focus on trade secret and non-compete cases and clauses. Non-compete clauses are common in investment advisor, employment contracts, and partnership agreements. Although they're widely used, the enforceability of these clauses is sometimes challenging. Today, we will delve into hot topics that are impacting non-competes, including evolving legislation and market trends. If you have any questions or comments during today's program, we encourage you to join the discussion by using the Q&A box on your control panel. We will address your comments at the end of the discussion and promise to follow up on any questions that we do not get to during our time together this morning. So with that, let's get started. Debbie, are you noticing any trends with regard to non-competes and other restrictive covenants in employment agreements?
I am, and thank you for allowing me to join you guys this morning, Andy. I appreciate it. One thing that we've seen in the last couple of years, and it really is accelerating, is an uptick in legislation that either restricts or limits the use of some types of restrictive covenants. I think it's useful to backtrack for a moment and just outline that there are a few different types of restrictive covenants that can be utilized. One is just a confidentiality agreement, which prohibits an employee from utilizing confidential information during or after employment. Those kinds of agreements are really not being attacked, so to speak. The other two types of restrictive covenants are non-compete agreements and non-solicitation agreements. Non-compete agreements restrict someone from entering into a competing field for a certain period of time post-employment. And non-solicitation agreements come in two flavors. One that prohibits someone from soliciting or accepting business of their former partnership or employment for, again, a period of time post separation. And one that restricts individuals from reaching back and trying to bring along colleagues, soliciting co-workers and employees to also leave the organization. So it's those latter types of agreements, the non-solicitation agreements, but most particularly non-competition agreements that are really becoming a focus of state, even local, and perhaps federal enforcement. So some of the things we've seen in the last few months, perhaps the most startling is a new law in Washington, D.C. that took effect earlier this year. And not only does it absolutely invalidate non-competes post-employment, but it actually prohibits employers from restricting an employee's ability to compete while they work for that employer. So an employer that deals with DC cannot say to someone that they pay, hey, while I'm paying you to do this work for me, you cannot go down the street and work for a competitor also. That is illegal in Washington, DC. Don't ask me for any rationale for that. I can't provide you one, but that is the law. And it applies not only to DC-based employers, but any employers who have individuals who work in DC or who may reasonably work in DC. So that's really at the far end of the spectrum of what we've seen so far, but we are seeing a lot more laws, such as one that is pending in the state of Illinois, which would set salary thresholds for non-competes and non-solicitations. Under the current version, which is expected to go through, it would prohibit non-competes for any individual earning less than $75,000 a year, and would restrict non-solicitation agreements for anyone earning less than $45,000 a year. And that would increase over a period of years, that salary threshold. Another important part of that piece of legislation is that the legislation would void any agreement that does not give an individual 14 days to consider the agreement and advises them to consult an attorney. If that provision or if that is not followed, the agreement will become void. It's like it never existed. So important things to keep an eye on. And in addition to this upsurge in legislation at the state and local level, there is increased talk that we could see some federal legislation. When he was a candidate, now President Biden did voice concerns about non-compete agreements. There have been a couple attempts in Congress in the past couple of years to gain some ground with non-compete legislation. Certainly, given President Biden's interest in that area, it is widely anticipated that we may see some non-compete legislation at a federal level too. Certainly something that we are keeping our eye on. And again, very important for folks to realize is that not only is this happening on a state and local level, but many larger cities are looking at or have enacted some type of legislation that restricts restrictive covenants as well.
Yeah. That's very interesting, Debbie. Kind of given that as a background, how can a company that operates in several different states, manage these challenges of changing laws?
Yeah, great question, Andy, and very important. First and foremost is now is the time to audit those non-competes. So I know a lot of times these are agreements that are put in front of somebody at the beginning of a relationship. They're put in a file, and they stay there until someone leaves the organization and you're looking at a potential enforcement action. That should not be what people are doing now. Organizations should be auditing their non-competes, pulling them out of those drawers, taking a look, and seeing if they need to make changes to those for employees who work in these municipalities or states that may be impacted. It's also important to note, particularly given this increase in legislation, that restrictive covenants should not be looked at as a one-size-fits-all. Many of the organizations I work with do just have a standard template. Anyone who they have signed a non-compete signs this one standard non-compete, and that's really not the best practice, the best way to go about this. Remember that in any state that does still allow enforcement of non-competes, one thing that a court will look at is it reasonably necessary to protect legitimate business interests? So given that, you want to be selective in when you really are using that top drawer non-compete. If an organization has everybody down to the receptionist signing a non-compete, it might be difficult to argue that it's really reasonably necessary to protect their legitimate business interests. Okay to have everybody sign a confidentiality agreement. And for many people who, for those who interface with customers and clients or vendors, stepping that up to include a non-solicitation provision is very important, and perhaps a non-compete. But non-competes should be thoughtful, and they should be used for key employees. And even when non-competes are used, again, they should not be a one-size-fits-all. Certainly, multi-state organizations need to have somebody who is taking a look at how do laws in the states we do business impact these agreements. And they also want to take a look at what type of work does this individual perform for the organization. If they have nationwide or international responsibilities, then it's okay to track that kind of geography in terms of a non-competition agreement. But if you're looking at somebody who deals with a certain set of clients, perhaps in a regional area, then it should be more tailored to that. That is going to enhance the aspects of enforcing these agreements if that becomes necessary. Another thing that's very important to note is that some states, and this is again on the uptick with this legislation, some states do not allow what's called blue penciling. That term refers to a principle under which a court has the ability to modify an overly broad non-competition agreement. And that's very handy. Ohio is one of those states. Delaware is one of those states. Many states do allow blue penciling. Now, that does not require a court to modify an agreement that it might find to be overly broad, but it has the ability to do so. There are other states that say no, a court may not modify an agreement. If it's overbroad, the entire provision will be stricken. In some states, the entire agreement will be stricken. So again, audit those agreements. Have somebody who has knowledge of the parameters of these agreements. Take a look at them. See if they are suitably drafted for these individuals, or if they need to be modified. And certainly, if you are modifying them, you need to be mindful of the fact that requirements for consideration may vary from state to state. So if you say, we've taken a look at this because of this legislation in DC or this other area, let's modify, or it's just time to update them, take a look at the laws, again, in the states in which you operate, because in some states like Ohio, continued employment, for instance, is sufficient consideration. That's all that needs to be done. In other states like Washington, it must be tied to some very specific considerations, such as a promotion or a raise, which the employee could reject in order not to enter into that new agreement. So it's very important to consider all of these things and keep those agreements up to date.
Okay. So say you've done that, or made reasonable attempts to craft a well thought out and reasonable agreement. Can a company then rely on it during the employee's employment?
Well, once again, very good question. And what I see very, very often in these things, and I litigate non-compete matters all around the country. And oftentimes, when I'm working with a client, it's the first time that they have had this circumstance. Someone leaves the organization, it's a trusted employee, they've been there 10 or 20 years, and all of a sudden they won't say where they're going, and a week or two later they find out they're at their their harshest competitor doing the exact same thing. And they sort through the files and they find an agreement that the employee signed 15 or 20 years ago, and they want to enforce it. And sometimes we can do that, and sometimes it's tough. Once again, these should be living documents. It should not be something that's just stuffed in that drawer. Okay, we did a good job. We had our lawyers look at it. We updated it. Now let's just put it in there, and it's good to go for the duration of the time the employee is here. Really isn't the case. So number one reason, which we just discussed, is certainly want to keep up with the changes in laws. And I would venture to say that whatever the state of that legislation is today, it's going to look different in a year. It's going to look different in 2 years. So you need to make sure that you are continuously updating those. I always urge employers, for instance, to go through their job descriptions on an annual or at least every 2-year basis and make sure they're up to date with what the employee is doing. And I urge the same with regard to non-competes. So not just because of changes in legislation, but other changes can happen as well. For instance, an agreement may be signed, and there may be a merger or an acquisition, or the company might change names or form a different type of legal entity. And if the agreement does not allow for the restrictions to pass to the benefit of successor entities, then there's going to be difficulty in enforcing that agreement if that becomes necessary. So you need to make sure that if there are changes in the organization, that those are addressed as well. There may be changes with regard to the employment situation. A long-term employee, let's face it, most long-term employees will evolve in their responsibilities with the company over a period of years. If they're there 15 or 20 years, chances are they are a successful contributor to the organization, and their value is changing and adding, and probably the scope of their responsibilities is increasing as well, both substantively and perhaps geographically. So a restrictive covenant that might be appropriate for a lower level employee that, say, may be defined by a narrow geography or perhaps a shorter temporal scope, might not be appropriate if the person who entered it into as a lower level employee now is a vice president of the organization and is guiding high-level strategy, making decisions about the future of the company, has access to all of the company's strategic information and financial information, strengths and weaknesses. A much broader non-compete might be reasonable for that particular person. And even I find sometimes in these types of agreements that they may define the person by title. And courts sometimes don't like to enforce restrictive covenants. So if there are any loopholes a court can find, if they define the employee by a certain title and now there's something else, that could be a loophole for the court to say, well, this only pertained when they did this certain role. they have evolved out of that role, and so we need to do something else. That restriction no longer applies to them. So it's really important that on an ongoing basis that there's some tickler system, and that folks bring those out and check them out on a regular basis, and if needed, provide some additional consideration, and also in advance consider what they're going to do if that individual refuses to sign the updated agreement. But certainly these are not documents that should be shelved and stuffed away somewhere and not considered again until that employee shows up on a competitor's doorstep.
Thank you. Aside from using restrictive covenants, what else can a company look to do to protect its sensitive information?
Yeah. I really see restrictive covenants as being a partner with trade secret principles. So typically, and again, I look at these oftentimes from the viewpoint of enforcement actions. And I think having litigated these, I can't count how many times over the last 20 years, that knowledge becomes very useful in how to draft a proper agreement up front and how to protect trade secret information. If an organization has a key member who leaves and goes to work for a competitor, yes, I hope that there will be a restrictive covenant of some type in place that can be enforced. But also probably that person may be jeopardizing an organization's trade secrets as well. Unfortunately, many times they have actually taken trade secrets with them in some document form or electronic form, but also in many instances there's a principle of inevitable disclosure that individual may just have so much key information, trade secret information belonging to the former organization, that it's not possible for that person to work for a competing organization without inevitably using and disclosing that information. And certainly, given this increasing status of legislation in terms of limiting the use of restrictive covenants, keeping an eye on how an employer can protect trade secret information outside of non-competes is increasingly important. So even in the absence of a non-compete agreement, even if you have a non-compete agreement that's been voided, organizations can rely on trade secret principles to restrict a former employee or former partner's operation within an organization, or sometimes can effectively create a non-compete, even though one doesn't exist, by showing that the individual could not work there without using or disclosing the trade secret information. So it's very incumbent upon an organization to be vigilant in identifying its trade secrets and in protecting those trade secrets. So what does that look like? And it's important because trade secrets are defined by information that is of such importance to the organization that they've invested a substantial amount of time and energy to it. It would put a competitor in an unfair competitive advantage if they were to have that information. And it ranges from things like processes and formulas to client information, preferences, pricing, margins, all number of things within an organization. Every organization has trade secrets. But in order to maintain an action with regard to its trade secrets, it has to also show not just that it has trade secrets, but that it took steps, reasonable steps, to protect the integrity of that trade secret information. So pre-COVID, that looked like something different. That looked like things like limiting access to certain documents and information, using password protections in computer programs. Again, limiting access to those who had a need to know, making sure visitors to a facility are escorted, perhaps not allowing cameras, having policies that folks acknowledge with regard to trade secrets. Again, having those confidentiality agreements, training folks with regard to what those trade secrets are, those types of things. Post-COVID, things have gotten a little more complicated. And the reason for that is we now have a lot more people who are working remotely. And that seems to be here to stay. We're all coming back to the office, but what it looks like is that there are many more employees who will be working at least part-time on a long-term basis remotely. We've seen many studies where employers have found an uptick in productivity, and certainly we've seen a lot of studies that employees enjoy the work from home benefits. And it's becoming a retention issue for many employers. So unwittingly, by allowing continued remote work, employers could be jeopardizing their trade secret information because they may not be taking those reasonable steps to protect the integrity of their trade secrets. And here's why. You got employees working remotely, and they may be working at the kitchen table with their roommate or partner working right across the table from them. What's happening to the employer's information? Is it laying on that table for that other person to see? Are they going to Starbucks or another coffee shop and working remotely from there, where someone could be looking over their shoulder? Are they cross-mingling documents? And by that I mean working from their own personal devices and co-mingling work information onto those personal devices. So it's very important to enhance an organization's policies to address those features. So I'll talk about that more in a moment, but we saw that really brought to light at the end of last year with a case that involved out of Delaware, I believe, that involved a franchising organization. And what happened with that particular franchise organization was that it was having some Zoom meetings to recruit potential franchisees. And so those franchisees could sign up, they got information from the company, they could log into this Zoom meeting, and trade secret information was shared. A couple of those folks who presented themselves as having an interest in the franchise actually weren't interested in being a part of the franchise. They were interested in getting the information, and then they went off and started their own competing business. The organization sued them, sought a preliminary injunction to stop them from competing, and said, hey, they stole our information, our trade secret information, to save steps and start up this competing company. And the court denied the preliminary injunction in part because it found that the organization did not take sufficient steps to protect the secrecy of that information because of its handling of that Zoom call. It did not even follow Zoom's protocols for security features. It did not require passwords. It did not take a roll call and identify who was on there. It even allowed folks who signed up and were interested in the Zoom calls to provide that information to other individuals. So there's no way to monitor who was on there. So that case, when I read that case, it was kind of a wake-up call that, gee, you know, this new world is really creating some different hurdles for employers in terms of protecting their trade secret information. So again, this new wrinkle is out there, and it's here to stay. What is an organization to do? Well, particularly with web-based functions, you should be having some security protocols and making sure that individuals are following them. But it goes beyond there. Updated training is necessary. Make sure people are trained on what your expectations are when they are working remotely. There should be policies in place that they should work in an isolated area of their home or their environment. So they should not be working in public where other people can view sensitive information. You should have policies for how they destroy any printed information. You know, not just leave it on the table, but there's, you know, you should require shredding, or that it's brought back to the office and destroyed there. But make sure that that's thoughtful and that is addressed. Many organizations are requiring increased security measures for folks at home, that they have sufficient security with regard to their Wi-Fi. That there are some organizations are doing multi-factor authentications to log into company portals. So it's important to take a look at your organization, what the parameters are, and how you might be able to best protect that information in this new remote work environment. One other thing that many organizations should consider with remote workforce, and even with their existing workforce, is taking a look at different types of monitoring. There are monitoring programs that you can adopt, computer-based programs that you can take a look at what folks are dipping into in terms of your information. So that can be a routine type of monitoring, similar to random drug tests, that there's a program that just periodically takes a look at what different employees, different people within the organization are looking at, what documents they're pulling up, what documents they're printing, they're accessing, they're changing on a regular basis. And if something looks suspicious, you can take a look. There are other types of enhanced monitoring. For instance, there is an ability to have alerts identified if individuals access key data. So key financial information, key customer data. Anytime someone accesses documentation electronically that falls within those key identified data sources, that someone is alerted, and you take a look and see if there was a reason, a justification for that person looking at that information. The third type of monitoring is usage-based. So oftentimes what we see is if an employee is thinking about leaving and going to a competitor, they are pulling together documents that they want to view or take with them when they go to the new organization. They are having a data mining event going on. So that certainly involves reviewing an unusual amount of documents and information. So you could have a tripwire set so that if an individual accesses more than a certain number of documents in a given day or a given time period, again, an alert is sounded, and someone can review and see if that is there is a legitimate business reason for that, or if that seems unusual. So again, more important than ever that those considerations are viewed given this remote work environment, given the restrictions on non-competes and non-solicitations. Make sure that you are really taking using due diligence and really reviewing your trade secret practices as well. Andy?
Great, Debbie. We do have a few minutes left, and we have a couple of questions, so we can get to them. The first question is, with respect to the DC legislation, you mentioned that it covers those working in DC and those reasonably likely to work for a company in DC. How does that play out for people working remotely for the company from time to time in DC?
Well, I think that that's an interesting question, because we do see a lot of people sort of traveling around and working in various places. I think, if someone was working, went to DC to get an Airbnb for a while and work from there, and left during that period of time to work for a competitor, I think it would be questionable whether a non-compete would be enforceable. So one thing that is also important for employers to do, given this new remote work world, is make sure that their employees are required to notify them where they are working, because not just for these reasons, monitoring non-competes and so forth, but there may be different payroll requirements or different laws that pertain to them from an employment-based perspective in those situations. So very important to keep an eye on that. Good question.
Okay, and then the other question is, have you seen any workarounds for employees that are concerned with non-competition covenants by crafting an agreement that focuses on restrictions around proprietary business interests?
Mm-hmm. Certainly, there are a lot of workarounds that can be made. Non-solicitations or no hires is one great way to achieve pretty good limitations without going all the way to a non-compete. Other folks do non-competes of a very short duration, or non-competes with just an identified list of organizations that they don't want someone going to. So, I certainly don't recommend that every non-compete be individually negotiated, but at a higher level for executives or for good reason, there are certainly a lot of ways that an employer can achieve their goal of having restrictions that protect their interests while still giving the employer or the partner some comfort level that they can earn a livelihood after they leave. So very important to work with a trusted attorney to draft a good agreement that adequately protects the organization while still creating something that the employee is comfortable signing.
Great. Thank you, Debbie.
You're welcome.
With that, we are concluding today's chat as it is 11 o'clock. Next week, we're taking a coffee chat break to celebrate the 4th of July. Our next coffee chat will be held on Wednesday, July 14th. My colleague Mark Miner will be joined by Bill Riley of Oyster Consulting to discuss resolving regulatory inquiries. If you've missed the past coffee chat, we encourage you to view our library of recordings, which are available on Thompson Hine's YouTube channel. We want to thank all of you who have attended today's program and extend a special thank you for Debbie for sharing her insights today. When the webinar ends, you'll be prompted to take a survey providing feedback. Thanks again and enjoy the rest of your day and stay well. Thank you.